because I'm spoiling myself, I got interested in the bullying question, and it went in an interesting direction. The question was, my son's school has a zero tolerance for bullying policy, yet every time we have something happen, they tell us it's not really bullying. According to who? My son thinks it's bullying. Now, we don't know how old this person is or anything about his particular eligibility or background. My son thinks it's bullying. I think it's bullying. Is there a definition of bullying that the schools are going by? School is saying it's just kids being kids, and they will talk to them. Frustrated. Well, listen, frustrated, from hearing your question, I get the feeling that you're in a small district that isn't keeping up with the times, because it's very easy to have a bullying problem on campus these days, and I don't think kids will be kids or boys will be boys. It's going to cut it. So let's talk about bullying generally, bullying under California law, and what kind of remedies people have. In California, it turns out, thank you readers for directing me to, or listeners for directing me to this, there is a specific definition of bullying under the education code. And so your school is always going to be bound by that policy, or that law, excuse me, and then each district will have its own, or should have its own board policy that you can go online and get. And I'm holding up Culver City's. My son was bullied all through middle school and high school in Culver City. I didn't have a clue as to what to do about it, mostly because it was occurring outside of school, after school, but it was occurring in front of me. And the worst it got was some kid filled up a squirt gun with urine and actually squirted him with it. So it was pretty egregious. It was, yeah, boys will be boys, kids will be kids. It was pretty egregious bullying, and when he got out of there, he never looked back. And I wish I'd done a better job and been more informed. But so what I found is that, first of all, the Culver City definition of bullying in their board policy is very, very similar to the education code. And the way I found this out is I printed out the Culver City board policy. And then I went and read an interesting decision that I'm going to talk to you about, which is a bullying case that I think the end result might surprise you. But anyway, Education Code section 48.900 says bullying is not defined within the IDEA, meaning it's not defined in federal law. Bullying is defined under the California Education Code for purposes of finding grounds for suspension or expulsion of a student as, quote, any severe or pervasive physical or verbal act or conduct by a pupil or group of pupils, including one or more acts committed by a pupil or group of pupils as defined in section 48.900.2, etc., directed toward one or more pupils that has or can be reasonably predicted to have the effect of one or more of the following. So this is what you have to be able to show: a fear of harm to your person or property, a substantially detrimental effect on her physical or mental health, a substantial interference with her academic performance, or a substantial interference with her ability to participate in or benefit from the services, activities, or privileges provided by a school. So this decision, Parent versus Los Angeles Unified School District, OAH case number 20150-50710, and if you remember the goodie, you can go look it up and read it if you want to. So this case was written by a very liberal administrative law judge who I don't want to tarnish his reputation by saying this on the air, but he's got a very good reputation with parents. And so you would think in this case everything would line up correctly to show that the bullying constituted a denial of a free, appropriate public education, which is one way that bullying is litigated. The other is kind of more of a civil rights issue. So this student, and this case I think kind of exemplifies a lot of the problems that you have, because a lot of the time the bully was bullied and becomes the bullier. And sometimes it's very hard to deal with this from a disciplinary standpoint, because children who are bullying, who have IEPs, are protected by IDEA, and it's difficult to expel them if their behavior is a manifestation of their disability, as you will see in this case. So I'm really just going to kind of like brief you on this case, and I think you'll see why we're talking about it. So the student was a 5-year-old, okay? So he was in kindergarten, and he was eligible under autism. And his mom was concerned about, his communication abilities, ability to read social cues, and safety awareness. And she had him in a transitional kindergarten in Hancock Park. There was another student in his classroom, and that child was also eligible for special education under autism, but his classmate was more severely impacted by his disability than the student was. So the more severe student began bullying the less severe student, and there were all kinds of problems because the boys were friends. So the classmate, he's referred to as classmate in the decision, was also pulling the hair of other students, biting them, or striking them. And the two kids, the student and the classmate, were about the same size, about the same age, and they socialized. And one day, without provocation, the student was punched in the eye by his classmate. And everybody talked about this. Mom was unhappy that they were in the same class, but the district said, well, we're just going to monitor the situation. I'm sure they were concerned that it would be very difficult to move classmate because of stay put. So then a week went by, and student is hit in the stomach by classmate during snack time recess, so maybe when there's less supervision. Mother tells student to stay away from classmate, and other students were told to also reinforce that. But student didn't want to stay away from classmate because he considered classmate to be a friend. So mom at this point requests an IEP meeting, which I think didn't happen as soon as it should, which is not a good thing for the district to ignore. They should have had a meeting within 30 days. But anyway, in the meantime, mom kept trying to tell student, stay away from classmate, he's going to hurt you, stuff like that. And mom sees at this time, and this is not unusual, that now student's behavior starts to change. He starts to tantrum, she feels he's more distant than her, and then in January, there's another incident. Student is playing in the yard. Student is playing with leaves, like tree leaves in the yard. Classmate became upset and hit student in the head. Student was sent to the nurse and given an ice pack, and then everybody met with classmate to try to correct his behavior. So, classmate was aggressive. He wasn't lightly hitting. He was hitting, hard. So mom sees that when she gets to school at the end of the day, student is not okay. She takes him to the hospital. He basically has a concussion. And so finally in February, we get around to the IEP meeting, and mom raises her concerns about bullying, but there's no agreement with the district saying, look, student has a 1-to-1 aide, that should be sufficient to protect him. And one of the things about this is we see students bullied with 1-to-1 aides, and that has something to do with the fact that you can't maintain 100% control over somebody all of the time. But I think it more usually is a product of a lack of skill on the part of the one-on-one aide, which LAUSD is pretty famous for. Anyway, no agreement at the IEP meeting. Student is adamant that classmate is his friend, and he wants to continue to be friends with him. And then on February 9th, classmate hits student over the head with a wooden block. At that point, the teacher decides that classmate is posing too much of a problem and he needs to be removed from the class. He is moved to another class. And mom decides that it doesn't matter to her anymore, and she actually writes the district a letter and asks for a non-public school placement. And there's another IEP meeting following this. They don't agree to the new placement. The district says, we don't think classmate's really bullying student because he's not demonstrating anger or being mean, and student isn't afraid of him. So you can see little echoes of kind of this, they're just kids being kids, or he can't help it. Anyway, so I'm reading the decision saying, well, surely he's going to find that the student was bullied. Meantime, student, not classmate, is becoming more aggressive toward other family members, is throwing things in the car, and is beginning to exhibit school phobia, which I think is kind of what you start to see. One time, student told mother, "I don't want to go to school, classmate hit me in the head." Toward the end of the school year, student became unwilling to do homework. Anyway, mom continues in her quest for a private school placement, and there's a hearing where various teachers and mom testify, and the administrative law judge gives you clues about kind of his thinking. And one of the pros he saw was that the non-public school had a bullying curriculum, and I might add parenthetically, one thing schools can do that they never do is sensitivity training, and not never, but not often enough. They need to do education about bullying. They need to involve other students in the role of being mentors and kind of protectors, and zero tolerance for bullying, and peers stop bullying when they see it happening. But districts don't usually spend the money on that. They're usually reactive. At the hearing, the district testified that kids in kindergarten do have problems keeping their hands to themselves. They would hit other kids daily. It's part of the curriculum. We work on this. And we think that classmates' problem was that he had no language, so he's expressing himself physically when he's frustrated. And to some extent, they felt that even though his actions were so inappropriate, he was trying to get attention from student. And so the teacher said, if this was happening to my child, I would be outraged. But on the other hand, students' academic performance didn't decline over the years, and I don't see any over the school year, and she doesn't see him being anxious in the classroom. So she's basically probably been instructed, I hate to say it, to testify that way by the district. Maybe not, maybe that's what she really thought. But anyway, student's witness was somebody that came from the non-public school and had a PhD in counseling and psychology. And this witness said bullying is generally committed by verbal taunting or harassment, while hitting usually represents aggression, which wouldn't necessarily really support parents' views. So I'm not sure why that was a testimony. Anyway, for autistic children, she said, hitting usually arises out of frustration, especially in younger children where the child has a communication deficit. So then the administrative law judge analyzes the facts, relates it to the law, and gives us a standard for bullying, which basically is, whether the bullying occurred and whether the bullying resulted in the student not receiving educational benefit within the meaning of IDEA. And he discusses, in his view, how the facts apply. And in doing so, there's just a couple interesting things he said. One was that the Office of Civil Rights had published something federally that said the definition of bullying includes a non-exclusive list of specific behaviors that constitute bullying, and specifies that bullying includes intentional efforts to harm one or more individuals. It may be direct or indirect, and is not limited to behaviors that cause physical harm and may be verbal. So that's a very broad definition of bullying. Anyway, the administrative law judge goes on to look at the other cases that we have that are on point to see how he's going to rule. And he says that basically, in one case, the parents removed the student from school after only 5 days. They didn't allow the district to have a reasonable opportunity to address the bullying, so that wasn't a denial of FAPE. If a teacher is deliberately indifferent to the teasing of a disabled child and the abuse is so severe that the child can derive no benefit from the services he or she is offered, that's where you'll be able to show that the student has been denied a FAPE. So it's a very high standard. Deliberate indifference is really a high standard, as opposed to, let's say, negligence. So then he says, in our case, there were 5 acts of violence committed by a classmate against student during the school year. He says that they were both kindergartners and they're still learning. He says classmates' more severe degree of autism prevented him from being able to express himself with words. The impact of classmates' autism was such that he had to be removed from general ed. He expressed himself by biting, pulling, and hitting. The physical acts committed on student meet the definition of bullying in California law. And then he says that the bullying, one of the things that's important about bullying is you look and you see if there's a power imbalance between the two people. Another is the frequency. And he says there were really only two incidents in 5 months. And so it's not really as bad as we think it was because classmate was removed from the class. So he's saying that, since there was, I guess, a 2-month period without an incident, 5 incidents in 6 months does not amount to frequent bullying. And I was really surprised about this because I thought, that the evidence was very strong. So he talks about how there was also evidence that the classmate didn't intend to harm the student. That was a factor. And he says district staff didn't ignore the bullying because they removed classmate from the class. Well, they didn't do any bullying education, but okay, they did do something. And student did not suffer educational consequences as a result of the alleged bullying. So there's apparently no denial of faith. So anyway, that's what happened. And student was said to have not established his burden of proof by a preponderance of the evidence, which is only a 51% standard. So this family was really being held to a very, very stringent standard, and they were successful in showing that bullying was a denial of faith. Well, this just happened to be the decision that I found. And there are, I'm sure, other ones that go the other way. But you can see if your child is being bullied, you're going to need a very strong record and a strong set of facts in order to make the claim that bullying constituted a denial of educational benefit. So that's, if you want definitions for bullying and what the rules are in your district, you can either go to the California Special Education Hearing Office database and read some cases. This is just the first one I found. There's probably quite a few under bullying, but you also should pull your board policy and look at it. And then it's going to be your job to convince the IEP team that the board policy isn't being followed. So that's the best advice I can for today on how to deal with bullying. And to some extent, the problem is, as parents, we're still going to have to be vigilant. We can't assume the school's going to take care of it. Anyway, that's probably enough about bullying for today.
It overwhelms me, Bonnie, because that decision makes me a little bit angry. Because to say there's only 2 incidences over 5 months, well, I was counting 3. And when we say 0 tolerance for bullying, that means, so if somebody goes to school and punches your kid in the eye, if we go by the strict definition, I mean, it did say in the first definition that you read, and correct me if I'm wrong, that it could be a single incident, but from what the judge was saying in the decision, it sounded like it has to be multiple incidents, and I don't understand why, if it's a 0 tolerance, why our kids have to go through something over and over and over again. I'm a big proponent of inclusion and giving kids an opportunity, and clearly something was going on with that other child and he didn't have the means to communicate. And I don't mean that means, I'm not a Jeff Sessions fan where I'm like, oh, that means he needs to be expelled. I'm not saying that, but clearly that other student needed to be in a more restrictive environment with people who were better trained for everyone's safety because he was acting out. And maybe he didn't have to be there forever, but to have waited that long to have moved the child, if I was this parent, I would be angry.
Well, yeah, exactly. This decision I brought to you, not because it's the best, most pro-parent decision, but because I think it illustrates some of the many contradictions and difficulties that we have in dealing with bullying. Because believe me, if I had been able to go and interview classmates' parents, they would have their own story.
Yeah.
And when the school district says there's 0 tolerance for bullying, that's not entirely true, because a student who has a disability is going to be hard to expel and even hard to move.
But
I mean, this student's parents, the classmates' parents could have invoked stay put and kept him in the classroom. You know, that didn't happen, but it could have happened. So, you know, I go back to, I'm not a bully apologist for anyone. I think we should have a mandatory curriculum on bullying, civics, and, you know, a few other things that I don't need to go into that would start in kindergarten. But, you know, but as we don't, it still becomes it still continues to be the responsibility of the parent to be hyper vigilant. And sometimes it's really not clear what to do. I mean, when the kids at Culver High came up and started bullying my son verbally in my face at the end of the school day, I knew it was bad because they weren't even afraid to do it in front of me. And I never arrived at a great solution except for graduation, and that's not acceptable.
Yeah.
You know, and Nick has written about his experiences being bullied in high school, and he didn't love it, you know?
Yeah.
So I think it's a really tough issue and one that we have to all get educated about. Particularly, there's like Hannah Hoovenen at UCLA is a bullying expert, and if districts want to, they can hire her and she can come in and she's got a plan for dealing with this. It's not...
We'll get her on the show.
Oh.
We will
If
get
you
her
would
on
like
the show.
to, let's connect you because she's fabulous.
I would love that.